a protective provision which is sought to be struck down as ultra-virus on account of it being discriminatory, not per se bad in law.
Jokingly, it says that the judges are law students who mark their own examination papers.
So we actually mark the examination paper
of other judges also.
Of the other judges and of lawyers.
Inquiry or inquiry, because there are two kinds of inquiries contemplated in CRPC, or investigation of offences relatable to recommendations made or decision taken by public servant in discharge of official functions or duties. No police officer. Now it's not CBI centric. It's general, any investigation. No police officer shall conduct any inquiry or investigation into any offence alleged to have been committed by a public servant under this Act, where the alleged offence is relatable to. Now, this is confined protection. Any recommendation made or decision taken by such public servant in discharge of his official duties. So that they take risks at times in decision-making process when the country is progressing.
Has to be there.
You have to take some new ideas, you have to implement new ideas, you have to give new ideas, advise the government about the...
Criticism is that if you take a very pedantic approach, and in a scenario where various issues are moving on, stagnation is not the solution.
So, therefore, a limited protection is given, expanding...
Yeah, this is for higher class of officers, those who take decisions and those who make recommendations.
Correct. But because that's the only level at which decisions are taken and recommendations are taken. What happens? Your lordships are aware, my lord, with my lord's experience on this side and that side, that at the level of the officers below who do not make recommendations, they only place the facts. These are the facts for approval, for guidance, for recommendation, for decision, etc. And the file moves. At some stage, you have to take a call. For example, Lord, we would leave the courtroom after making our submissions. No responsibility. Your lordships ultimately takes the call, whether one is right or the other is right. And that is that decision-making process which is sought to be insulated from vexatious proceedings. And it's not a prohibition. It's kind of a protection that my senior will be asked whether I would have committed any...
It's a check.
It's a check, yes.
It's a check or a protection for any government servant now, irrespective of the hierarchy, who may be involved in a process of decision-making, which is a bona fide exercise of decision-making process. It may not be right to say, I'm not sure, whether at the higher level only. Because suppose you are right, they say, we put up the proposal, do something. But tomorrow somebody may say, even that is wrong, putting up the proposal. So the protection is given where a process is followed. You will not say the subordinate officer is not protected because he was the initiating person. The initiating person also, in a way, is a proposer. He is also equally required.
I'm obliged.
So
what happens?
Suppose tomorrow he on record shows completely wrong facts and tries to elicit a decision on the basis of wrong facts. That's a different scenario.
It's a proposal, may not be recommendation. What happens? Well, suppose in a contract, in an award of tender, he would say that these are the three tenders, these are the plus points, these are minus points. This system which is offered is better system, but little costlier. Now place it for consideration. Sometimes you have to take the risk of costlier system which is more effective. So that's the idea. Now, Lord, the Subramaniam Swami judgment found that it is too broad and it's my lord, over wide. It's completely, there is no check. Now it is suitably tailored that every action is not checked, every action is not protected, or rather, every action is not sought to be, there is a layer of inquiry before you are subjected to criminal inquiry or investigation. Only these particular acts. My apprehension is that your lordships, in case say that 17A is only a different avatar of 6A, that might have an impact on the pending proceedings where they say 17A.
What you were saying that 17A seeks to cure the defect which resulted in 6 being struck down, which is that it was discriminate. So you have tailored 17A in a narrower compass, you say, but cures that defect which resulted in the judgment.
Correct.
That's the only thing.
So, my lord, if your lordship, my lord, can carefully and suitably, my lord, word it that that is not affected.
Why do you think you will not suitably and carefully?
I leave it to your lordship. And my lord, third apprehension, my lord, this is an apprehension as an officer of the court. Not, my lord, this is not the government's apprehension. Lord, the law, my lords are aware. Law whereby the honorable bench declares a declaration of unconstitutionality to be prospective only is derived from Article 141 and 142. There is no other jurisdiction, and therefore Supreme Court has said that it is only your lordships who can do that. High courts cannot declare it to be prospective in application. Now, my lord, the law is that whenever a bench decides a particular list or particular question of unconstitutionality, that bench knows what has transpired before our declaration of unconstitutionality, what events have passed by, and what would be the consequence if prospectivity is not given. So it is, my lord, my submission is that the law is, it is only that bench. I'm not on this case, my lord. I have no objection if it is held prospective. It is only that bench which decides whether to make it prospective or not. If any other bench subsequently were to decide, we will have floodgates of litigations because several provisions might have been held unconstitutional without making it prospective. And now we may have petitions that now please declare that because of ABCD reasons, that judgment delivered 10 years back will have only prospective effect, or 2 years back will have prospective.
In some way, in framing the question, it became a retrospective and prospective issue. A little digression from it, at least in my view, the issue was only that a protective provision which is sought to be struck down as ultra-virus on account of it being discriminatory, not per se bad in law, but discrimination is causing the consequence. You have to construe it in a particular manner. Not saying, my brother Justice Oak itself said, we can't do it. We can't say if it is violative of a constitutional part 3, that it will have only prospective effects, because that doesn't exist. But we'll have to tailor the peculiar problem which we have here. That's all we are looking for.
Lord, the suggestion is, if your lordships can consider saying that without laying down the law in view of the peculiar facts arising this, let this be held prospective because very few number of cases are going to be.
Open even to say that this is, it is not prospective in that sense, but being a protective order, what is to be done? Maybe we use Article 142 to complete justice between the parties.
No,
but in the given scenario, 142 is only for scenarios like this.
because
But
when there is no,
we are not laying down the law that change the principle that unless it is set prospective, apply retrospective. All that kind of thing. Those may not have.
difficulties, and I'm fagging my lord as a student of law again, not my lord as a party appearing.
That all of us are.
Yes. My lord, jokingly, my lord, it says that the judges are law students who mark their own examination papers.
So we actually mark the examination paper
Of other judges also.
of the other judges and of lawyers also who are making submission.
Yes, my lord, your lordships are right, my lord. And sometimes, my lord, the assessment takes place in the chamber,
Yes.
may not be in the courtroom.